with Sam Seder.
The destiny of America is always safer in the hands of the people than in the conference rooms of any elite.
Sam Seder.
They are unanimous in their hate for me, and I welcome their hatred.
We must guard against the acquisition of unwarranted influence, whether sought or unsought, by the military-industrial complex.
The Majority Report with Sam Seder.
If I get the feeling you've been cheated.
It is Monday, July 1st, 2024. My name is Sam Seder. This is the 5-time award-winning Majority Report. We are broadcasting live steps from the industrially ravaged Gowanus Canal in the heartland of America, downtown Brooklyn, USA. On the program today, Melissa Jacoby, law professor at the University of North Carolina, Chapel Hill, author of Unjust Debts, How Our Bankruptcy System Makes America More Unequal. Also on the program today, the Supreme Court rules that a president has absolute immunity for official acts and makes it near impossible to prove an act unofficial. Also on the program today, top Democrats panic as Joe Biden's family wants him to stay the course. U.S. to offer a plea deal on criminal charges to Boeing. Steve Bannon heads to prison today. For 4 months, he's going to miss the election, or he'll get out just in time. A Trump-appointed federal judge blocks Oklahoma's criminalization of undocumented immigrants. And the Texas Supreme Court upholds a ban on gender-affirming care for youth. U.S. removes the aid pier in Gaza, maybe permanently, because of weather. This as Israel takes more steps to annex the West Bank. In France, the far right leads in the first round of snap elections. Good job, Macron. Runoff happening next week. And the general who led the failed Bolivian coup attempt claims he was ordered to do it by President Arce to help flagging poll numbers.
Evo Morales also says that.
Lastly, the Biden administration rejects mining access to the Alaskan wilderness. All this and more on today's Majority Report. Welcome, ladies and gentlemen. Thanks for joining us today. Rather busy Monday.
Not Fun Day Monday.
Not Fun Day Monday.
Sorry, guys. It's a violation of our branding, but we had to say this is not a fun day on this Monday.
I just want to say, we just got the Supreme Court ruling happened about an hour and a half ago on immunity. Tomorrow, we're going to be talking Ian Millhiser about the Chevron case and others. We may actually have somebody else on Wednesday to do so. I know it was virtually impossible to get a legal analyst for today because they all knew that they were going to be writing their pieces on these rulings.
And I also don't think we anticipated that over the weekend there would be this level of conversation about Biden dropping out of the race either when the debate happened.
There is a lot of talk of Joe Biden, of people wanting Joe Biden to leave the race. There's also now a lot of talk of people saying, why can't Joe Biden officially go over to the Department of Education and take a hammer to the computers that have all the lists of people who owe money?
He should.
I mean, it seems like an official act.
I want him to be, like, if we're really going to go down with this octogenarian ship, I want him to be like an absolute criminal and just go really hard.
Someone should project Bulworth over on the White House.
Yeah, the down with the ship thing doesn't really work because it's like if the Titanic, you couldn't get on the life raft. You just had to stay on the ship with the captain. Be like, okay, we'll go down with you, buddy.
Yeah, right.
You didn't want to give up the ship.
America's just a giant suicide pact, apparently.
This ruling from the Supreme Court is a little bit worse than we had Ellie Mistel on last week. Was it last week? Maybe it was 2 weeks ago, to give us a potential preview of this. And he felt like it was going to be remanded without a doubt at that point. He thought that his speculation was that it's probably not absolute immunity, because otherwise that would have come out earlier, and they may have negotiated a remand. And it appears actually to be worse than I think a lot of even the most jaded Supreme Court watchers have followed, in part because there does not seem to have been a particular test for unofficial or official acts that can be broadly applied. And to the extent that there was a test that was applied, the court also found that you really cannot get evidence. And we'll get deeper into this tomorrow, but you cannot collect evidence, or I should say, you cannot collect almost the only evidence that would be available to establish that something was an unofficial act. Because it's rare that a president says, I'm personally going to do something illegal. Usually what it is, you talk to your advisors around you and you delegate that authority. And if you don't have the ability to in some way subpoena the communications between those people, then there's no way to know if the president had any culpability in doing this act that could be non-official. But here is Ken Delanian from NBC as this news broke, how he was characterizing this decision. Again, we'll be talking to Ian Millhiser tomorrow and probably somebody on Wednesday about this and the other decisions, but that we've had in the past week. But there could be no more stark of a reminder of the import of not having a Republican president than what we've seen in the past week. And frankly, I don't know how many years it's going to be before we can unwind this stuff. And by years, I mean decades, probably, particularly with the Chevron doctrine last Friday. But I don't know, maybe if the president's has absolute immunity, there's a little more opportunity for Biden to do something, assuming that, he's capable of doing it. Here is Ken Delanian.
Let's bring in NBC's Ken Delanian outside of the Supreme Court. Ken, what do you have?
Yeah, Katie, I think the analysis here has been spot on. The decision goes a long way to say that the president is not above the law and that private acts, unofficial acts, are not immune. But if you look at what the implications for Jack Smith's indictment of former President Trump, they appear to be dire, because there's a whole section in the indictment about Donald Trump's efforts to enlist the Justice Department to allegedly falsely proclaim that there was fraud in the election, write letters to states. That is completely out, according to this decision. And then you get to his conversations with Vice President Mike Pence, which are a key part of the indictment. This decision says that there's a presumption that those are immune, but that prosecutors could seek to rebut that in the lower courts. And then it also says that his public statements, the public statements of any president, are largely immune. And so the speech at the ellipse, any social media, the tweets, the Truth Social posts by Donald Trump about January 6th, that is largely out of this case. What is possibly remaining in the case are Donald Trump's and his allies' conversations with state officials, with private parties in their efforts to get state officials to conduct investigations into bogus allegations of fraud. And what this decision says is that all that has to go back down to the district judge, who has to scrutinize in close detail every single one of these allegations and decide what constitutes private conduct, what could possibly be official acts. And then, of course, that's appealable. And so the idea that this case could go to trial before the election is completely out the window. That's not happening. And in fact, it could take a year or more to sort through this stuff even if Donald Trump doesn't win the election, in this case, still goes forward. This Supreme Court decision greatly complicates this major indictment of Donald Trump by the special counsel, Katie.
We're going to talk again. We're going to talk to legal experts about this, but it appears that as long as you're dealing with federal government apparatus, there is no unofficial act that you can take as president, which is just absolutely bizarre.
That's going forward. And then, as mentioned there, this also retroactively hamstrings Jack Smith and the federal prosecution from using a big tranche of evidence against Donald Trump in the January 6th case.
That's all because it has to do with, I mean, it sounds like if you were the president and you ordered as commander in chief the military to take over the government on your behalf, that by this definition, it would be legal. Now,
that sounds very
say you're
official.
Richard Nixon and you tell the CIA to say, put this Watergate thing to bed. Would that be an official act?
I mean, this is, we're going to be talking again to Ian Millhiser tomorrow about this, but here is Sonia Sotomayor. She wrote a dissent, I think also KBJ did as well, or added to it, I should say. She wrote, looking beyond the fate of this particular prosecution, the long-term consequences of today's decision are stark. The court effectively creates a law-free zone around the president, upsetting the status quo that has existed since the founding. This new official acts immunity now, quote, lies about like a loaded weapon, end quote, for any president that wishes to place his own interest, his own political survival, or his own financial gain above the interests of the nation. The President of the United States is the most powerful person in the country and possibly the world. When he uses his official powers in any way, under the majority's reasoning, he now will be insulated from criminal prosecution. Orders the Navy SEAL Team 6 to assassinate a political rival? Immune. Organizes a military coup to hold power? Immune. Takes a bribe in exchange for a pardon? Immune. Immune, immune, immune. Let the president violate the law. Let him exploit the trappings of his office for personal gain. Let him use his official power for evil ends. Because if he knew that he may one day face liability for breaking the law, he might not be as bold and fearless as we would like him to be. That is the majority's message today. Even if these nightmare scenarios never play out, and I pray that they never do, the damage has been done. The relationship between the president and the people he serves has shifted irrevocably. In every use of official power, the president is now a king above the law. I mean, so, again, we're going to talk to Ian Millhiser about this, but someone who seems to be fairly well versed in constitutional law, that being Sonia Sotomayor, believes that the standard that they have set, there doesn't even seem to be any type of like balancing test.
So much for original intent. I mean, this is exactly like, even in the rosiest depiction of the founding fathers, which we, I think, eschew, you could say that they didn't want a king. But this is exactly what allows for more executive power, almost king-like, as Sotomayor says in this
She is saying that basically all that it takes to constitute an official act is not the intent, it is not the outcome, it is not the motivation. It is simply the fact that, are you the boss of this person? Under the way that the Constitution and statutes were, are you the boss of that person? In that case, you can tell them to do something illegal, and you, as the president, have no liability for that illegality.
This is a failure of liberal institutions and the maintenance that the Democratic Party thought that they have been operating under for many, many years, as opposed to being proactive. They've been putting a paint job on this corrupt Supreme Court. I mean, I hope Dick Durbin's enjoying his vacation right now, but I want people to look at this and understand that because of like an octogenarian class in the Democratic Party that's held on to power for way too long, we have allowed for a right-wing takeover of the Supreme Court. This began when Ruth Bader Ginsburg refused to retire under Obama because she wanted the first female president to appoint her replacement, and died right before Trump left office. And then that was how Amy Coney Barrett got onto the court. So this is a problem with liberals in this country broadly. I mean, just from a philosophical perspective of just maintaining these institutions that are crumbling as opposed to proactively correcting them. And then also a class of Democrats, and we'll talk about Biden later, but who are clinging onto power despite their clear age limitations for their own self-interest, as opposed to the very dire interests of this country at this moment. We are at a critical point, and this should not scare people into refusing to have this conversation about Biden right now. It should remind people of the perils of allowing for these very powerful people to hold on to power, even when we know that they're nearing the end of their lives.
I mean, there's also, a cohort of people who don't take the court seriously as an electoral matter. And, that I think there's plenty of blame to go around. Obama, refusing to put multiple nominees up and use that at least on a political level. It's really, this is bad stuff. And people are asking, what prevents, let's say, Biden under this ruling from putting 4 new justices on the court? What prevents student loan forgiveness to be found unconstitutional? The real, as far as I can tell, and again, this just came out, but the real danger with this ruling is for things like that, the government can be enjoined from doing them, right? The Supreme Court can find that it's illegal, and that's, it's actually literally more like Joe Biden would have to order the education department to go and erase all of its files, do it immediately before anybody, says anything. And then he couldn't be punished for it. But really, like, where this is going to give a president the most free rein is to do things that are not public and cannot be enjoined by the Supreme Court. In other words, you tell the CIA to assassinate somebody. After the fact, the Supreme Court can say, we enjoin the CIA from carrying this out. This is that's the area where this is really the scariest. It's really given a full license to, like, well, I did my best with the coup. I failed, but at least I have no recourse. I get another bite at the apple, essentially, as president. That's the real problem. In a moment, we're going to be talking to Melissa Jacoby about another element of our law, that is bankruptcy. She's written a book, Unjust Debts, How Our Bankruptcy System Makes America More Unequal. Johnson & Johnson just did this Texas two-step to get out from under, or attempt to get out from under, a big ruling they owed for, I think this was around the asbestos in Johnson & Johnson baby powder, or essentially the cancer-causing elements of it. We will talk to her in a moment. First, a word from our sponsor. Going online without ExpressVPN is like leaving your laptop unattended at the coffee shop when you run to the bathroom. We were just talking about, like, we end up having to post the election, do the show from a secret place. We would have to run it through our VPN, our ExpressVPN on our router, just to make sure that we couldn't be tracked. We're not quite there yet. However, though, there's a lot of, when you go online now, it is obviously, it is precarious. I want to thank ExpressVPN for supporting the Majority Report. And here's the deal. Visit expressvpn.com/majority. You can get an extra 3 months free every time you connect to an unencrypted network. Those are in cafes, they're in hotels, they're in airports. Sometimes you just connect as you're walking around. There's public Wi-Fi. in, I don't know, like sometimes some of these big shopping places too. Your online data is not secure. Any hacker on the same network can gain access and steal your personal data. That's passwords, that's bank logins, that's credit card details. It doesn't take much technical knowledge to hack somebody. Just some cheap hardware is needed, and literally a smart 12-year-old could do it. Tried to convince my son. He's only 11, but trying to get him to get there. Your data is valuable. Hackers sell this stuff. They can sell it and make $1,000 per person selling your personal info on the dark web. ExpressVPN stops hackers from stealing your data by creating a secure encrypted tunnel between your device and the internet. It's super easy to use, folks. That's the thing about this. It sounds intimidating if you're not technologically savvy, but it's actually one of the easiest things on my phone to use. You download the app, you hit one button, all the stuff on your phone is now protected as it goes out to the internet. You can also put this on your computer, super easy to do. You can even put it on your smart TV or on your router. Very, very simple to use and provides you with a lot of security so you don't have to worry about this stuff going forward. Secure your online activity by visiting expressvpn.com/majority today. That's expressvpn.com/majority. You can get an extra 3 months free. expressvpn.com/majority. We'll put the link in the podcast and YouTube description. And just a reminder, it's your support that makes this show possible. If you want the show free, the free show free of commercials, become a member at jointhemajority.report.com. Jointhemajority.report.com. All right, quick break. When we come back, we'll be talking to Melissa Jacoby. We are back. Sam Seder, Emma Vigeland on the Majority Report. Want to welcome to the program Melissa Jacoby, law professor at the University of North Carolina, Chapel Hill, author of Unjust Debts, How Our Bankruptcy System Makes America More Unequal. Professor, welcome to the program. Before we get into bankruptcy, which I think is far more intriguing for people than one would think, and I say that as a son of a bankruptcy attorney. I just am curious, as a law professor, when you see the Supreme Court's ruling today, I'm sure you haven't had too much time to look at it, but I suspect that you might have some thoughts. What are your first thoughts on that?
Well, it has me thinking about power. It has me thinking about who's above the law, and that's a scary thing. Today's a somber day in that regard.
How do you guys, let me just ask you, like, broadly speaking, has there been, over the course of your career as a professor, an increasingly sort of cynical, has it been hard to fight the cynicism? Like, there is the idea with the law and lawyers is that, the Supreme Court justices would never start with a ruling and then reverse engineer, and that the law is very much based upon, the sort of the foundations that have been set over the common law and, of course, over the course of the of this country's history. How are you hanging in there as a law professor when so much of the sort of the varnish seems to be coming off that?
Well, I come from a long line of skeptics. There have always been people who understand that courts don't merely call balls and strikes, even when they say they do, that a lot of different factors go into how they rule, that there are political elements, that there are other factors. Now, the ability to weather the cynicism over time is a different matter. I do think it becomes harder, but I try not to think about this regarding me. I think about it regarding the American people. Yes, sure, in the last week, we know a lot of law professors have had to start changing what they're going to teach in the fall and what they're going to tell their students, but that's secondary to what the real world effects are of all of these decisions.
Yeah, and let's talk about that in the context of your book in Bankruptcy, because you're right. The bankruptcy law is something that touches perhaps more Americans than just about any other type of law out there, either because as individuals they deal with bankruptcy, or they're dealing with the implications of a corporate bankruptcy, or for that matter, a municipal bankruptcy. But let's just start with, before we get to bankruptcy, let's start with debt. And just like, if you could compare and contrast the implications of debt for individuals, for separate people, what we all perceive as people, and debt for what you call fake people, which are basically not just corporations, but any entity that is organized, may not necessarily be a corporation per se, but it could be a church.
For real life human beings, for families, there often is a strong need to use debt as part of their social safety valve. This is a society that has a lot of risk put on the individual and the household, even for things that are out of their control. It has been increasingly that way, and credit is what fills the gaps. At the same time that individuals are incentivized to use credit and incentivized to take on debt for all sorts of things, the narrative around when they need to cancel some of that debt is very finger-wagging and very unapproving in this country, no matter the circumstances, it often seems. And there's an effort to turn neighbor against neighbor in terms of judgment of why one person can't handle all the debt they have when someone else tries to do so. When we flip to the corporate environment, especially big corporations, I think the story is very different. Certainly corporations have lots of incentives to borrow, and sometimes are given rates that are considered extremely cheap when the average American family could use some cheap credit too, but it's not always available on those terms. And when they do run into trouble, the story is different. It's looked upon as a more rational strategic decision of how to move forward, and people are more likely to look at the broader consequences and say it's better for everyone if we let this company reorganize in bankruptcy. And so talk about economic efficiency and those sorts of things. We don't hear as much of that story with individuals, but we really should, because we can make a lot of the same arguments there.
There's a moral stigma associated with personal bankruptcy. It's almost the complete opposite for corporations. And then it's sort of almost like an astuteness at certain times that's associated with that. I mean, that's by design. isn't it? I mean, in terms of like, that's by design. I mean, we talk about bankruptcy adding to the wealth inequality and a couple other sort of measures of inequality, I would argue as well. By making bankruptcy a stigma on a personal level, that's by design, right? I mean, that's because the people that are the creditors on a personal bankruptcy are much more powerful. There's a power dynamic there that's different if a corporation has creditors, because a big corporation is going to have creditors who are probably less powerful than the corporation.
Well, and you mentioned the word power, and I think that's really important because bankruptcy looks like it's about debt and money, but really it's a lot about power, which I think makes it fit in the narrative of what we're talking about today in court decisions and the like. Democrats and Republicans often don't agree on much, but in 2005, they joined together to say that bankruptcy should be more complicated and more expensive for financially distressed families in this country. And they proceeded to do exactly that. And they did that at the behest of the consumer credit industry, although there were a lot of other interests that piled on that effort as well.
How much?
I should just add,
yeah,
that was Biden's bankruptcy bill.
Oh yeah.
Right.
Yes.
I mean, your former professor, I mean, that was sort of almost like her origin story in terms of entering politics. I mean, prior to then, she's writing for Talking Points memo and talking about personal bankruptcy and that bankruptcy bill. And I want to get to, how it basically excluded student debt. But that bankruptcy bill was a Joe Biden, I think, drafted legislation, if I'm not mistaken.
Well, you're absolutely right in the general sense. I'd say the consumer credit industry wrote a lot of the legislation themselves. But at the time, as a senator from Delaware, he was very active in mobilizing that agenda. And he also was not receptive to pushback from fellow Democratic senators who were starting to have concerns. Now, he has come a long way on all of these issues. I want to give him credit for that. People do change their mind or at least change their policy.
Right.
But it's part of the record that he was very actively involved and made it difficult for Democrats to dissent from those positions.
Yeah, he was from what they call it, the credit card state, or he always represented those interests throughout his history in the Senate. How much of the punitive nature about debt comes from the outgrowth of debtors' prisons, or basically the fact that they were done away with, I guess, in the mid 20th century, it basically being a continuation of that without having to lock people up for it?
Well, the irony is that there's a real difference between locking people up and the approach we have now, although both end up somewhat in the same place. Here's what I mean. When people are locked up for not being able to pay their debts, which sometimes still happens in corners of our world for certain kinds of obligations, but in general it doesn't. People can't repay debts while they're incarcerated. There aren't the mechanisms for them to make money in enough quantity to actually repay creditors. The problem is that, so we move out of that and we go into a system that says, what could possibly be wrong with encouraging people to repay as much debt as possible over time? They're not imprisoned, so surely they can devote some of their future wages to this. But there's lots of research showing that it just doesn't work that way, especially with the costs and fees on some of the credit, where people might have paid the principal several times over, but will never, ever pay off the debt. That is then going to change the choices they make about starting businesses, the education their children receive, and everything else in ways that aren't good for anybody. So whether the theory of the two comes from the same place, I don't know, but the practice ends up not being as different as it looks. I often say that we're supposed to have bankruptcy in America, an effective debt cancellation regime, so that we don't have to have Squid Game. We don't want to live in a Squid Game world where people fight to the death because that's the only way that they could pay off their debts.
All right. So, I mean, we have this concept of bankruptcy, which in and of itself is good. I also like the concept of bankruptcy because it expresses that, like, look, things don't always work out the way we want them to, and we still want to come out. It's a bad situation, and you want things to come out as beneficial for as many people as possible associated, both the people in bankruptcy and the creditors and society at large and whatnot. And so you do this. I mean, I like that concept. I would like to apply to a lot of our public policy things. But as you write it here, when the rubber hits the road, what happens is that bankruptcy seems to work for some people in that fashion, at least aligned with that concept, but not for others. And again, it basically falls to, for the less powerful, it doesn't work in that way, broadly speaking. And for the more powerful, it does. So let's just talk about, you give two examples of sort of fictional real people, I guess, that are aggregates of the type of things that people run into. One is Sylvia, and the other is Linda. And describe these two, because one is in chapter 7 and the other is in chapter 13, which are the two personal bankruptcies. And they have very different implications. And they also turn out to have not only different implications in practice, but they are correlated, and I think you would argue with reason, to specifically how people are located in our society and down to even race.
Yes. So the stories in the book are intended generally to make sure that people see this is not an abstract exercise to write about this, that the public can and should read this book on Unjust Debts, and that these are real people that are affected, and to show examples of how people who get into financial trouble trying to do all the right things end up facing a system that makes things very difficult to get out the other end. Sylvia starts having to take less time at work because she's caring for a sick mother. And when I used to do and be involved with the Consumer Bankruptcy Project, which did studies of the real people in bankruptcy over time. And I can tell you, Sylvia looks like a lot of the people that have gone through the bankruptcy system. And then one thing after the other happens. She loses her job. That means she loses her health insurance. When she ultimately gets another job, it may not pay as well. The benefits may be lesser. In the meantime, she did try to use credit cards because she was sure that things were going to change the next day. And that's partially what they're for, to fill the gaps when you can't pay 100% at one time. And so we go through Sylvia's story to start with a portrait that I hope most Americans can understand, that it does sound like someone they know or themselves could end up in that position. When we move to Linda, Linda is an African-American woman living in North Carolina who's trying to save her home from foreclosure. And this piece does come from my sitting in a courtroom of testifying under oath that she had applied for 1,000 jobs to no avail. This was in the midst of the financial crisis. She was doing everything she could and then taking odd jobs, trying to get help from family, renting out her house, anything to try to keep things going forward. She was against an uphill battle, however, because the only kind of bankruptcy that she could use to potentially save her home is this thing called Chapter 13, which is a repayment plan. You have to commit every last cent that you have, basically, to this plan. And it's still not going to help Linda because of the costs of her loan and the fact that she can't get another job. However, there are a lot of people in Chapter 13 who look like Linda. They're African-American families who have financial distress, who have been steered there even though they don't have a home to save. And ultimately, what Unjust Debts is trying to convey is a large body of research. I cite to the people who do all of this really important work that shows that African Americans are systematically getting less debt relief at basically a higher price in our American bankruptcy system.
Well, all right, and for folks at home, that's what we call systemic racism, where you don't necessarily have an institution that's doing it, but there is a system that is for any one of myriad reasons is providing worse outcomes because of people's race. So why would I be eligible for Chapter 7 versus 13? And then how in practice does that end up creating a racial disparity when we look at the numbers?
Well, when Congress rewrote the law in 2005, they might not have intended this, but one thing that they effectively did is make it impossible for me to explain that in a very short period of time. They made it so complicated. Basically, one of the messages from that law was that people who had too much income, if you were wealthier in terms of income, you should go to Chapter 13. And if you were less wealthy, you can be in Chapter 7.
Wealthy as defined by income as opposed to assets, because
yes,
what ultimately why you end up with more or a higher incidence of Black people being pushed into 13 is because there was also a corresponding higher incidence of Black people being put into very insecure mortgages during the lead up to the financial crisis.
Absolutely. I'm given the theory. It's not working like this in practice. In reality, the vast majority of people who file for bankruptcy have low incomes across the board. And African American families are homeowners at a way lower rate than white families in America. Their mortgages are more costly. However, that's not what's driving African Americans into Chapter 13. It's the fact that all those new twists and turns, well, this is one of the factors anyway, all those new twists and turns made lawyers charge even more money to file. Now, I shouldn't make it sound like they're charging a whole lot. They charge for an entire case what some corporate lawyers make in an hour over in corporate bankruptcy. So everything has to be in perspective. But for a family who's already spent their last dollar trying to keep themselves out of bankruptcy, they don't have it. Chapter 13, you can pay your lawyer over time. And in Chapter 7, you're supposed to pay your lawyer up front. That is hitting African American families very hard. But it is more than that, I have to say.
So there's a predatory aspect of this in terms of, or is it the attorneys are approached, they see someone with no assets to pay them up front for a Chapter 7. So they're basically forced, their clients are forced into a Chapter 13 because they don't have the means in which to pay for a Chapter 7 proceeding, essentially.
Well, I'm going to hold back on the word predatory. I think some of these lawyers' offices are very small businesses working on not a lot of resources. So this is where the second part of the disparity comes in on the filing level. There have been studies that show that when families are given two families with the identical financial circumstance, but one has features, their names, what church they go to, that signals that they're Black, and another that signals that they're white, lawyers will make very different recommendations for those two families, that they will recommend the longer, harder approach to bankruptcy, the more expensive approach for African American families more frequently than they do for the white families. And so where I'm going with all of this is that...
Do we know why?
Well, those who are researching this come up with a couple theories. There is some stereotyping going on. There's some understanding of who is more and less responsible. Lawyers, even in another study, when asked to estimate how many white people and Black people are in Chapter 7 and Chapter 13, bankruptcy lawyers overestimated the white people in Chapter 13 and underestimated the Black people in Chapter 13. Again, the law professor and psychologist who worked on this talked about stereotyping, and we often call it implicit bias that's going into this. But I don't know
So it's like almost an analogous dynamic to doctors prescribing less painkillers to African American patients because of some combination of like they don't recognize the legitimacy of the pain that African American patients are in, or that they have some notion of like, I have more exposure here because I have some unconscious or more or explicit belief that they're more likely to be painkiller abusers or something, or drug abusers. I mean, so it's that type of dynamic, whether conscious or unconscious, by these attorneys.
Well, I think you're right to make some broader analogies here, because this is not a phenomenon unique to bankruptcy. I think the message I'm trying to convey in Unjust Debts is the hierarchies and biases that we see in society are reflected in bankruptcy, but then they're really compounded because of the tools and the consequences of the bankruptcy system. But I do think that looking at other circumstances where it might be implicit is important, because we have to solve this problem together. It's not going to be about pointing fingers at people and calling them racist. That's not going to work. On the other hand, we do need something done about this. There has to be structural reform to the personal bankruptcy system, because that is the most important thing that our bankruptcy system does, is provide debt relief. And we have to reduce that racial discrimination. We have to seek to eliminate it, if at all possible.
And frankly, the overall, not just that disparity, but the way that personal bankruptcy operates versus, let's say, Chapter 11, which is corporate bankruptcy, is much more problematic, because if I go into Chapter 11 as a corporation, I get immediate protection, and that is one element that's problematic. The other is this so-called Texas two-step, which I think our audience is a little bit familiar with in the function of we do a lot of coverage of mass tort cases, whether it's this Johnson & Johnson case over talc, which was found to be cancerous, or DuPont with the PFAS case, or with the Sacklers and Purdue. The bankruptcy is now being used on a corporate level as a way of escaping not just debt from creditors, but almost like a future debt or a hypothetical, because it's a liability because they've harmed people.
Yes. So in talking about the types of concerns I have about corporate bankruptcy, we start with the idea that, again, on a bipartisan basis, Congress decided to do a protective expansion of the ability of a company to reorganize. That's kind of an extraordinary thing. They don't have to be dismantled. They get to continue. And the idea is that it's better for workers, better for suppliers, better for communities, and there has to be a certain amount of buy-in from creditors. It works pretty well when done in a traditional way. And by that, I mean with creditors who have contracts that, whether they're suppliers or whether they've loaned money, and a case that goes all the way through and the creditors vote and it follows the blueprint that Congress chose. There are two ways that cases are going off the blueprint. One is cases moving super fast and selling companies within weeks or months without all the protections for everybody else. But the second that's gotten so much attention right now is that because the bankruptcy law defines debt so much broader than our common conception, people are sweeping everything in. And while I think Congress knew that it could be in sort of an ad hoc, that there might be some tort claimants in a bankruptcy case, when Congress wrote the bankruptcy code in 1978, they did not anticipate it's being used only for tort claimants, and especially, as you've pointed out, Sam, for people who don't even know that they're injured at the time of the case. And that's an issue that is really left open by the Purdue Pharma decision in the Supreme Court, although I can see how some people will argue it's closing the door to that. There's a good argument for that, but it really wasn't centrally presented in the case.
And so, in other words, that a corporation can realize, oh, we've harmed maybe 1,000, maybe 10,000 people, or 100,000. We don't know exactly yet because the case hasn't even gone that further, and use bankruptcy to escape that liability that is just hypothetical.
Well, it is hypothetical, and let me offer what the corporate restructuring lawyers would say in response to what you just said, which is they're not escaping it. They are managing it so that the money is allocated equally to people. Now, that sounds good in theory. I've written about in the book and in a New York Times essay a couple weeks ago that that's not how it works out in reality. What's promised is not always delivered. But there is money set aside to pay people. A lot of it does go to lawyers. Let's just make that clear. But it's not a complete blockage. But these cases are so much more than just about money. They are about control. They're about accountability. They're about people who've been injured telling their stories. And all of that goes by the wayside, at least in modern bankruptcy practice. I think there are things that can be done if these cases stay in bankruptcy. But there was an optimistic story to this. Senator Elizabeth Warren, who's going to be interviewing me later today for the Commonwealth Club at 3 Eastern Time, used to believe strongly that if there was enough information about what the company did wrong and enough lawsuits that have already happened, that it might make sense to try to package everything together, set up a trust that's adequately funded. That's right. The key, adequately funded, and that so people that are hurt 10 years from now aren't out of luck. I'll be curious to see if she asks me questions about this and how it's working now. But there is an optimistic part of the story. I'm just very skeptical that it's working that way, and that it doesn't resolve all of the questions we should have about it.
Is there any movement in Congress to reform the bankruptcy laws, either, to include things like student debt or to decrease the harshness between Chapter 7 and 13, or I should say 13 and 7, and to minimize this opportunity for corporations to escape liability, and also simultaneously deny plaintiffs the opportunity to sort of get compensation in other forms, some accountability. Is there any movement on this in Congress, or are we just in an era of the law in this area is just sort of fallow for the moment?
There is movement on these issues. Now, getting them over the finish line, of course, is a very different story. There actually are legislation, there are bills on every issue that you've raised, including pushing together Chapter 7 and Chapter 13 so that there's one personal bankruptcy chapter that would do so much to address the racial disparities, especially given some of the technical details of that law. There are bills that try to look at sex abuse bankruptcies and give, by which I mean the Boy Scouts, Catholic dioceses, all of which are filed only to deal with child sex abuse allegations. A bipartisan bill is dedicated to looking at giving more of a voice to the survivors and making sure that these entities are honest about where they've planted their various resources when we're talking about the diocese or anything else. The question is the movement for that. And one reason I wrote Unjust Debts for the public and not to talk about only in the faculty lounge is because, again, these issues relate to corporate power. They relate to everything we've talked about around elections, and it should be part of what people are concerned about, or at least is consistent with what people are concerned about. So that there needs to be more pressure from the public to look at these issues to make the system more fair.
Melissa Jacoby, law professor at University of North Carolina, Chapel Hill. The book is Unjust Debts, How Our Bankruptcy System Makes America More Unequal. We will put a link to that at majority.fm, and really appreciate your coming on today.
Glad to be here. Thank you.
Thank you.
Okay, folks. We're going to head into the fun half and talk about all the fun news of the day. Not the least of which, the Supreme Court has basically said the president has full immunity. And really, full immunity, understand, like, the areas in which a president would need full criminal immunity are really the ones where he would only, or she, would, or they, for that matter, would do stuff that was quietly illicit. So in other words, like, I love the ideas that this means that, Biden can go out and do whatever he wants. But the problem is that the type of stuff that you want Biden to do is exactly the type of stuff that can be stopped beforehand. It's done. I'm going to do student debt relief. I mean, there's no criminal charge associated with a president incorrectly ordering student debt relief. It's a civil case. A lawsuit comes in. The Department of Education is enjoined. This is what has happened actually with this.
Right.
The only thing would be like if Biden said, I'm going to hire some guys, we call them the plumbers, and they're going to go over to the Department of Education and take all the records of people's student debt and burn them. That would be more akin to something that I guess theoretically he could do. Now, those plumbers would be criminally liable, but there would be almost no way.
But if, say,
to find out whether
Jeff Zients orchestrated it, those communications between Biden and Zients would not be a part of
admissible. Yeah,
admissible. It's absolutely insane. So Biden, I guess, could steal a candy bar from like the local 7-Eleven. That would be an unofficial act where he could be prosecuted. But say if he were to
tell Zients to steal it for him, Zients would be liable, but Biden wouldn't be.
Wouldn't be.
I mean, that's what it seems like to me. We're going to talk to Ian Millhiser tomorrow about that, but I suspect that's around where we are.
It's like a whole generation's myths being sort of snuffed out, basically, about like, the Nixon era, like no man is above the law. And the question of, well, he actually got a pardon that we never really, he stepped down, so maybe that's a punishment. Now we've decided, no, actually he was above the law. The only reason he's out is because of politics.
It would be interesting to see. I mean, look, he may have faced criminal charges after the fact, but an impeachment is not a criminal proceeding. But it would be interesting to go back and see, what did Nixon do? If there was a need to pardon him, what did Nixon do that he wouldn't have complete immunity from, or wouldn't be admissible that is going to be a fun exercise.
I mean, one of the reasons, say, H.W. Bush got involved is one of the people to get into Nixon and say, hey, actually, you have to skedaddle, is putting pressure on Dick Helms of the CIA, saying, hey, I'm having the FBI's looking into this Watergate stuff. Can you, like, tell them to knock it off? Because it might get into national security stuff. And that was inappropriate. Because, yeah, I mean, but turns out it's not really about the principle. It's about the bureaucratic.
Well, how about, like, let's just talk about the some recent examples, like Biden leaning on potentially the State Department to come up with some sort of conclusion that the Israeli government has not violated human rights abuses is an official act, even though, like, I don't know. I think you could make an argument that putting your thumb on the scale in that process is a violation of the Leahy law, right? But wouldn't that constitute an official act?
Well, I don't know that. I mean, I don't know that Biden pressuring an agency to come out with with anything would necessarily be criminal per se. Like, I mean, I think that's the. Maybe you could argue that he's conspiring to violate the Leahy Act. I guess I mean, that seems conceivable. That's seems a tougher call. I mean, because I think really, the realm of things that the president could do, I think that they're really just more like limited to things like, I guess, telling the State Department to make an assessment that's bad, right, is different than saying to the CIA, kill somebody. Yeah, no, it's clearly a criminal act.
It's amazing because this actually applies more directly to less quotidian criminality from the presidency, like to more outrageous acts.
That's what I'm trying. That was my point.
That was my long way of getting to that point. Yes.
Yeah, that's my point. Is that it's almost just like the worst stuff a president could possibly do. This basically gives them immunity for. But again, we'll talk to Ian Millhiser tomorrow. I suspect people are going to be speculating on the broad. We know short term what this means is Donald Trump will not go to trial for the most serious of charges that he faced.
The worst stuff.
And the implications for future presidents, I suspect people are going to speculate on for an extended period of time going forward. Also, in the fun half, we probably will discuss the incredible amount of stories around either Biden's fitness for the presidency or his candidacy, and the reactions of various players in the Democratic Party to the debate, and the fact that Hunter Biden is one of his top advisors, apparently, on this question as to whether he should stay in office or not. Hunter Biden may have a little skin in the game.
May also not have the best judgment. I don't know if that's been talked about at all.
They have an interest being served by having his dad have certain powers.
Well, yes, that's the point. But yeah.
It's almost as if Hunter Biden could get addicted to the attention or the power or something like that. I mean, I don't know if that's out of the realm of possibility.
I mean, the guy could have good advice, just not necessarily the best judgment when it comes to his own life choices. But it is, I think he definitely has a vested interest in his dad still being president, sometime after the election when he may, need a sentence commuted or two. In the meantime, Emma, ESPN.
We are going to do ESPN tomorrow after the dust settles on NBA and NHL free agency. So we'll be talking about all of those moves. Lots to talk about. Paul George going to Philadelphia. We've got some trades and free agency opening up in the NHL and more. YouTube.com/ESPN show for tomorrow at 4 p.m.
Matt.
Yeah, we had a good show, patreon.com/Left Reckoning for members with Chip Gibbons of Defending Rights and Dissent, who I mean, strongly implied that Defending Rights and Dissent was among the folks to get Rashida Tlaib to come out in support of Julian Assange on Julian Assange's release. So check that out, patreon.com/leftreckoning, if you want to hear from one of the people sort of central to this effort and what it means as far as free speech goes. Bottom line is the Espionage Act still needs to go. Patreon.com/leftreckoning.
See you in the fun half. 3 months from now, 6 months from now, 9 months from now. And I don't think it's going to be the same as it looks like in 6 months from now. And I don't know if it's necessarily going to be better 6 months from now than it is 3 months from now. But I think around 18 months out, we're going to look back and go like, wow. What? What is that going on? It's nuts. Wait a second. Hold on for a second.
The Majority Report.
Emma, welcome to the program.
Hey.
Matt.
What is up, everyone?
Nomi Key.
You did it. Let's go, Brandon.
Let's go, Brandon.
Bradley, you want to say hello?
Sorry to disappoint everyone. I'm just a random guy.
It's all the boys today.
Fundamentally false.
No, I'm sorry. Women's
Stop talking for a second and let me finish.
Where is this coming from, dude?
But dude, you want to smoke this 7A?
Yes.
Hi, me? Is this?
Yes.
Is this me?
Is it me?
It is you.
Is this me? Hello? Is this me?
I think it is you. Who is you? No sound. Every single frickin' day. What's on your mind?
Sports. We can discuss free markets and we can discuss capitalism.
I'm gonna go throw up.
Who libertarians? They're so stupid though. Common sense says, of course.
gobbledygook.
We fucking nailed him.
So what's 79 plus 21?
Challenge Matt.
I'm positively quivering. I believe 96, I want to say.
857-210-35-501 1/2 3/8
9/11, for instance.
$3,400